Good afternoon and good morning. I'd like to welcome you to the Louis Brisbois webinar on the future of amateurism in college athletics. My name is Greg Clifton. I'm the chair of the Collegiate and Professional Sports Practice Group, and we're very fortunate today to have one of our senior associates, Christina Stylianou, with us, who will be co-hosting this along with me. And more importantly, we're very fortunate to have one of the finest Division I athletic directors, Jill Bodensteiner, with us, who's going to give us a rare opportunity as we discuss some of the interesting issues that are facing amateur sports right now in our country. Unlike lawyers who talk about the rules and the laws and what's potentially happening with cases, Jill's in the trenches every day. Jill is running a Division I athletic program at St. Joe's University, and she's been kind enough to and willing to share some of her precious time with us and our audience to be able to sort of give everyone an idea of what she deals with on a daily basis and all the issues that have been going on really for the last couple of years, which seems to have become highlighted since we had the beginning of NIL and the issues relating to that, and which is all kind of steamrolled through a transformation committee with the NCAA and now numerous pieces of legislation. But again, we might talk on those pieces of potential legislation or the litigation, but our goal really today is to give Jill an opportunity to share with you some of her insights and some of her experiences. And I'm going to pass it off to Christina right now to give her an opportunity to formally introduce Jill.
Sure, yeah. So, hi, everyone. I'm Christina Stylianou. I'd like to formally introduce Jill. Jill is the Vice President, Director of Athletics at St. Joseph's University in Philadelphia, where she's responsible for 20 intercollegiate teams, 19 of them competing in the Atlantic 10 Conference. Before joining St. Joe's in 2018, Jill spent 20 years at the University of Notre Dame, first as an attorney in the Office of General Counsel, and later as a senior leader in Notre Dame athletics, focusing on legal, policy, and governance issues. And outside of those roles, Jill served on every NCAA name, image, and likeness committee during the last 4 years. She currently serves as both the NCAA committee on academics and the Division I women's basketball committee. And in the spring of 2017, she relocated to Washington, D.C. to serve as a fellow with the Lead One organization. And during that time, she spent a lot of time educating university government relations officials on the issues facing college athletics. And before we begin, Jill, I'd like to thank you so much for joining us and for being our guest today. I had the pleasure of externing for Jill about 10 years ago when she was the Senior Associate Athletics Director at Notre Dame, and I was a law student at the school. And Jill, to me, has just been such a great person to learn from because of the wealth of knowledge and experience and just deep involvement in college athletics that she comes with, especially in NCAA compliance and women's sports and Title IX issues. So I'm just especially excited to have you here with us today and to get to explore the changes that have arisen and shaped college athletics in the years since I had the opportunity to work with you, and really even just in the last couple of years alone.
Yeah, thank you so much, both of you, for the introduction and for having me. And Christina, it's great to see you again and interact in a professional capacity. And yeah, I love having these conversations because I think there's such a gap between what the general public learns through the media and what's really going on. And talk about, presumably there's several lawyers on the call, and talk about your two careers colliding. I grew up as an employment lawyer. My dad is a retired civil rights attorney and law professor, and I spent a little time at Cypher Shaw and Brian Cave doing employment law, and went in-house at Notre Dame focusing on employment law and athletics. So this is really a collision of my two worlds, and it's really, while other people find it sort of a nightmare, I'm geeking out on it. So happy to be here.
Definitely. So our discussion today is going to focus on amateurism in college athletics, and more specifically the possibility that over the next few years, student athletes could be deemed employees. So I think the natural place to start would seem to be the Supreme Court's Alston decision that came out in late June 2021. Alston, of course, was a pure antitrust case involving only certain education-related benefits that student athletes may receive. And yet, I guess through a combination of the decision's timing and Justice Kavanaugh's concurring opinion, which basically called the NCAA's arguments for amateurism basically illegal and circular, Alston's become embedded in our minds as like the moment that the tides turned in college athletics. Like not even 2 weeks after that, the NCAA changed its rules to allow student athletes to profit off their name, image, and likeness rights for the first time ever. And generally in the last few years, we've seen this historically popular debate over whether student athletes should be deemed employees of the universities pick up steam and actually look like a real possibility. We've seen states propose legislation to legalize the payment of student athletes through a variety of different approaches. We've heard comments from the NLRB suggesting that student athletes should be deemed employees, and the Third Circuit recently heard oral arguments in the Johnson case. Jill, I'm curious, in your view, what impact you think Alston had or maybe didn't have on that issue specifically, and how has it contributed to the develops we've seen in the space since?
Yeah, I promise I'll get to your question, but I think first, what happened really is when salaries started going up and media rights deals became exponential. And then there started to be a series of antitrust lawsuits looking to chip away and, establish that antitrust applied to the NCAA. So, the cost of attendance issue and the definition of a scholarship case law was sort of the first major shift. And Alston had a significant shift, probably at least equal to, if not more significant than the California state law proposal. So when the California bill came out with its name, image, and likeness rules, and then Alston came, sort of shortly after that, that really changed the landscape. And so, as I'm sure all of our viewers and audience know, right now there's been a hard line on compensation by institutions. And so what you're really talking about in the post-Alston era and Johnson and otherwise, is that line gonna be blurred even more. And so, I go back to the cost of attendance. So, for forever and ever, and this seems like such small potatoes now, but when I was at Notre Dame, we were in a total panic over this. But, forever and ever, the NCAA and its members have defined a scholarship to include tuition, room and board, books, and fees. And that's by NCAA rules. So the argument in the cost of attendance case was that, antitrust, you've colluded to set the value of a scholarship below what the value of a scholarship could be for other individuals who attend an institution. So that would include room and board, tuition, books and fees, plus personal and miscellaneous expenses. And that's what the federal government, Title IV financial aid regs say, that every institution should publish their full cost of attendance. And so, from an institution's perspective, when that rule changed, because it had to, and we defined a scholarship differently. So again, tuition, room and board, books, fees, and now personal and miscellaneous expenses. The first order of business was what are those? So we're looking at a lot of the elite private institutions in America. Those personal expenses are kept fairly low, because when you publish the full cost of attendance, if you already cost $68,000 and your full cost of attendance, your personal and miscellaneous expenses are $6,000, then suddenly your published cost of attendance is $73,000, $75,000. So both sticker shock and the fact that a lot of elite private institutions offer full financial aid for those in need. And so that's based on the full cost of attendance. So what you saw after that rule was changed was a flurry of activity of institutions relooking at their cost of attendance to determine what those personal and miscellaneous expenses should be. So at St. Joe's, ours are about $1,400 a year. Some larger public institutions are up to $6,500 a year. Now, athletes, particularly those on full ride, see that as their money in the pocket, right? And so if you look at a football athlete who's probably going to play 5 years, the exceptional ones can obviously go pro after 3, but a lot of them redshirt and play 5 years. 6,500 times 5 is a decent amount in your pocket. And so there was a real rush to relook at that amount, because when in recruiting, the athletes now say, what's your cost of attendance stipend? What am I getting in my pocket? Right. So that was the first wave of this, of the sort of compensation in the hands of student athletes, because they don't see a penny of tuition. They really don't see books, and they don't see fees. Those are paid directly to the institution. Now, room and board is interesting because that ends up, depending on your campus's housing policy, that ends up being cash in the pocket. So if an institution X has a $17,000 room and board and a scholarship athlete on full ride moves off campus and they get a bunch of buddies and live 5 to a house, they're pocketing 17 grand and paying out maybe 9,000. And so, room and board was sort of the only cash in hand until cost of attendance came up. So that was the first thing to fall. And then obviously post Alston and post California State Bill, NIL, and we could talk a little bit more about NIL if you want. So now here we are, and as you mentioned, and in large part thanks to Alston and this chipping away over the years, we're now in a situation where we're looking at erasing that line where institutions don't pay athletes. And as you mentioned, Christina, that's obviously coming up through the NLRB, through FLSA legislation, and also through revenue sharing proposals that are bubbling up both in state law and among the federal Congress is saying, if we're going to help you out and give you any of the 3 things you want, NCAA, we're going to want something in return. And to be clear, the 3 things that the NCAA wants are, number 1, a limited antitrust exemption. Number 2, a clarification or a statement that student athletes are not employees. And they want that to be clear out of Congress. And number 3, they want federal legislation on name, image, and likeness. So antitrust exemption, not employees, and federal NIL legislation. And there are some senators who are saying, if we're going to give you any or all of those, what are you going to give in return? And a part of that should be revenue share. You should take your multimedia rights and share that with the student athletes as compensation. So that was a really long answer. You teed it up well, but I thought I'd give a little where we've been and where I see us going.
If I could just jump in for a second. You mentioned the 3 points, which I think have been reported pretty clearly over the last several months: the antitrust exemption, the recognition that student athletes are not employees, as well as some type of federal legislation on NIL. If you took each one of those separately, do you think they're going to have to be combined as a unit, or can each one of those be dealt with separately and perhaps Congress only passes 1 or 2 of those as opposed to all 3?
Yeah, it's a great question, Greg. I've been just through my committee service, and this is not an NCAA opinion. This is one person's personal opinion. I think we need to be very clear on what our priorities are. When you go into any negotiation, you've got to be really, really clear. And there are some people that say, well, NIL, because it's a mess right now, that should be priority number 1. And there are others who would say priority number 1 has to be the employment. We're already dealing with NIL. It's a mess. So I think most of my colleagues would hope for all 3, but understand that all 3 might not be possible, especially depending on what we're willing to give. And so my personal ranking would say employment, NIL, and then antitrust exemption.
Okay. Well, and following up to that answer to that question, I appreciate that prioritizing, which is very helpful for us. I just had a quick question. Now, you mentioned NIL, and obviously you're a school that doesn't have football, but your basketball program is certainly nationally renowned among some of your other sports. How have you as a university and in your role as the athletic director put into place any of the things that make sure you're in compliance with the amorphous current NIL rules from the NCAA as well as state legislation? How are you dealing with that on a student by student level within the university?
Yeah, great. Another great question. The answer to that is very cautiously. So I think the lawyer in me understands that a lot of what's happening now is people looking to profit off of student athletes. And so, I can't even begin to tell you the number of vendors who reach out to me and want to get in front of me. We can make your student athletes rich. And there's always the fine print. And so, what everybody said, I'm not opining on this. I think the general public was sort of like, you're all getting rich off the athletes. Well, now we've opened the door to a second group who want to get rich off the athletes. And so there are some horror stories about student athletes signing deals with fine print, right? Locking them into 6-year deals when they may be a pro. I remember the closest thing I've seen in my time here is when the NCAA finally opened the doors to allow student athletes to get disability insurance. And so they always allowed kind of PTD, right? So like I give the example, if I was a football star and, maimed in a farming accident, I could have permanent total disability insurance to cover me. But the NCAA never allowed what's called loss of value. And loss of values, Jalen Smith, linebacker, Notre Dame, over projected top 5 pick, tears up his knee in the bowl game. Loss of value insurance would kick in and say, oh, you don't need to be permanently and totally disabled. We'll pay out the difference between the second pick and the 35th pick, right? So when the NCAA said you can get loss of value insurance, the floodgates opened and every insurance broker, and I'm using air quotes for those who can't see me, started selling loss of value insurance to student athletes who had no business buying it, who were going to be undrafted free agents anyway. And so there's no payout. But there was actually fine print that said not applicable to injuries sustained during varsity athletics. And
Wow.
There was no market protecting athletes from, because it was, and somebody sued USC saying the university should have kept me out of the fine print. And we're saying we're not insurance brokers. I can't help. When I was in the compliance office at Notre Dame, I did my darndest. So anyway, what we're seeing now is just hundreds and hundreds of vendors who want a piece of the pie and want to make money off of student athletes. I think there are a couple vendors, literally a couple, who are doing this for the best interests of the student athletes. So I've been extraordinarily cautious. We don't know enough about group licensing for me to sign a group licensing deal. I'm going to handle those on a case-by-case basis. I've made everything voluntary. Some schools have mandated it because our student athletes have so much going on in their lives. They've lived through COVID. They've got, our country's been, a bit of a tragic situation between COVID and racial injustice and now mental health. And I don't want one more thing that my student athletes feel like they have to do. So we've kind of gone team to team. Our field hockey team is top 10 in the country. They've got some stick deals and, some headband deals and things like that. Some of our lacrosse, we have the best face-off guy in the country, Zach Cole. He's running camps and clinics and using his name, image, and likeness to promote face-off lessons in camps. We're getting much better in men's and women's basketball, and those athletes are starting to get some deals. So I've been much more in-house, hands-on because of my knowledge than I have been signing up with vendors, much to their chagrin. So we're really going about it sort of grassroots and slowly. Some things that people, just to give you an example, there were two early deals that everybody was signing up for. One was an ingestible. I'll leave the name out of it because it's not important, but something you can take. I'm sitting here right now with a clean juice, right? So it's something that athletes can take to allegedly enhance their performance. And that company was going out trying to sign up every athlete. And what they got was a promo code, right? So everything that they put on social media, they got a promo code and could get free product. Well, meanwhile, the NCAA has banned substances and the FTC says you can't promote a product if you don't use it. And so the last thing I wanted is all my athletes promoting this product and having to use it because it's FTC says you do and get caught with a banned substance in their system. Mm-hmm. So those are the kind of things that we're really, we know where our student athletes are getting deals and where their risk is, and we've been trying to focus on those. And I would be remiss if I didn't mention I'm a huge NIL fan. I think it's long overdue. I see women who will never have a future in marketing because there's no professional sport getting great deals. It's awesome. However, I think it's really clear that everyone understands that there's a legitimate market and an illegitimate market. And the illegitimate market does nothing but say, we have boosters who created a collective and we're going to pay a sum of money to get a student athlete or to keep a student athlete. And that is not tied to any sort of fair market value. And that's creeping up everywhere. And then there's the legitimate market that says you're a really good gymnast with an amazing following, and I'd like to pay you to promote our product. So I am all about bucket one and very skeptical about bucket two, recruiting inducements. So again, I'll stop there and see if you guys have questions or comments.
I'm curious as to how, how the schools are doing, because we talk about this a lot now, that this wave of vultures that has kind of set in and is taking advantage of student athletes. I know that that's also how Charlie Baker's been casting it, as I think he made a comment about consumer protectionism being a concern of the NCAAs at the moment. But with the guidance that came out in October, I think, from the NCAA that said, financial literacy, help from the schools in terms of sort of guiding the students to protect themselves, that those things were only allowed if the school was offering it to other athletes as well. So what are the schools really doing to protect their own students from things like this?
I mean, the good news, I don't disagree with what Charlie Baker is saying, but the good news is the student athletes who are making big dollars have representation. We have Jordan Hall, who's now in the San Antonio Spurs. He was here. He had a marketing rep and an agent helping him with those. And the good news is, buy one field hockey stick, get one free is not exactly the kind of thing that's going to leave a student athlete at considerable risk. And so I think I don't disagree that there are vultures and that we need to protect them. But I think part of what gives me some sanity is the ones where the deals are generally and have been represented. But what are we doing? And I'll tell you what we're doing, and what I think most people are doing is educating the heck out of, right? I'm not going to give you a list of agents, because what do I know? If things go wrong, then I get sued. But we're going to tell you, here's 10 questions to ask your agent or marketing rep. And here's do's and don'ts on contracts. And we did an 8-page guide on how to run a summer camping clinic, and it includes insurance and background checks. So if anybody, those kind of education. And again, I'm not going to have a mandatory session for all 487 athletes where I say, listen to me talk about FTC. But if we hear of somebody, Zach Cole's starting clinics, like, we'll get to him with that material and say, hey, here's what you need. I don't want you to start this big camp without insurance or without background checking your counselors. So, I feel like our student athletes would say that they've been well informed and protected. And here's the rub. So this is, I think, where some of our membership is. So more people say we want the institution to be able to be totally involved in these deals. So that sounds good, right? Because we're protecting the student athlete. Like, we need to all recognize that means that some of the Power 5 schools are going to have 30-person NIL departments with lawyers, with marketing and agents and reps. Like, there's no gray area. They're either doing it or they're not. And if you have a lot of money and a 30-person staff is nothing, then we're starting to look a lot less like amateurs. If the institution, not to mention the have and have nots, I can't do that. I can't afford that. I can't afford your services to come in and counsel my athletes. And so I think we've got our members thinking a couple things. One, our student athletes, some of them are being preyed on and are entering better deals, and we're the best position to help them. Also for recruiting, we want to be able to sell our 30-person NIL shop. Let's be honest, that's a huge part of it. And then others are saying, wait a minute, like I said, there's no gray. We're either doing this and we become mini law firms and agencies, and we're duplicating those across 350 Division I schools to some degree. It may not be a 30-person department. And in that case, is that the institution's role? Are we now stepping way out of bounds of becoming an institution of higher education?
And also, I think you touched on it as well, Jill, which from my perspective, and I think Christina will agree with me, from a legal point of view, you're also opening up the colleges and the universities to a lot of potential liability if something goes wrong with those deals, or somebody gets injured at a camp or something like that, where you are now almost essentially the guarantor of those particular performances, whether they be by student athletes or whether they be organized by your student athletes. Either one, they're problematic potentially.
100%, Greg. And when USC got sued on the disability and loss of value insurance, I was the one screaming to the institution, if you want me to advise student athletes on this, we need every disclaimer and every waiver in the world, because I am, again, I'm not an insurance broker, and we can hire a bunch of in-house lawyers to handle all that. But not only does that put you on the hook for liability, as you appropriately raised, Greg, and has been demonstrated with the USC case in the insurance realm, but What about Title IX, right? So now, it's clear that the illegitimate market is going 99% toward men. We are not hearing of quite as much, here's $1 million deal for you just to flat out come to X institution, which is illegal under NCAA rules, but enforcement's another issue. So once institutions start being the ones negotiating deals, then that's pretty clearly, I think we would all agree, under the bounds of a program or activity of an institution receiving federal funds. And so there's where I want the student athletes to be protected, and that's why I hope we can have some NIL legislation like a boilerplate contract that says something, for example, that this deal ends the minute your eligibility is voluntarily or involuntarily over. I think there's a lot we can do without building up law firms within our athletic departments.
That's a great point. I don't know if Christina was going to go in a different direction, but I thought we'd take a minute because we don't have limitless time with you. You've done a great job. We might go back to some of the NIL stuff because I think Christina might have some additional questions. But one of the things that I want to make sure we covered with you, which I think is really important that we hear about what seems like on a regular basis, and I keep hearing rumors about other cases, is this modification or change from student athlete, the term you and I use and Christina uses on a regular basis, to quote unquote employee. And we were just wondering, we want to get your perspective on this as a Division I athletic director. Where do you think things are right now in terms of obviously the lawsuit in your neck of the woods, the Johnson case, not to mention what the general counsel, Ms. Abruzzo, and the unfair labor practice charge that is currently pending, and rumors I hear about potential EEOC charges alleging racial discrimination as a basis to have certain athletes made employees under the EEOC. So just curious to get your thoughts on where all those issues are at.
Yeah, I think they're coming. And, what you hear, there's sort of a famous line now that's whether it's a president or athletic director or a conference commissioner saying if student athletes become employees, we're out of the business. We're getting out of college athletics. And so that's not a real thing. I don't think that's real. And so what I feel like is missing in our current in the current status, in the current state of the industry, is problem solving short of saying we're canceling Division I athletics. And so, my coaches are worried. They hear that and they think, gosh, we're a Johnson decision away, whether that, presumably would take several years. If it doesn't go the NCAA's way, I would presume, and you guys know better, that it would be remanded and a normal trial process would break out. But our coaches are nervous about that. And some of our student athletes are nervous about it too. And so there's got to be a group of people working toward what would this look like, and how, whether it's rev share, as I mentioned earlier, or employment status, how could we reach a compromise? And, just to demystify with my coaches, we had a coaches meeting a couple weeks ago, and I divided them into 3 groups. And I said, we're only spending 30 minutes on this because you're all busy. And I said, group number 1, your job is to create a position description for a softball pitcher. Group 2, your job is to come up with our wage scale. Are we going with minimum wage? Do you get more your senior year than your freshman year? Does it based on merit? Are we paying more for contributions? And group 3, come up with compensable time, right? Here's everything I think an athlete does. What am I missing? And, what's compensable and what's not. So when you hook up to the stim machine before practice, is that compensable? When you stretch after practice, is that compensable? I mean, you guys are FLSA lawyers and experts. And, when you're driving on the bus, when you're golfing, and there's 2 hours of downtime within your 4-day golf tournament. How is all that compensable? And my goal was, I think I probably ended up freaking out my coaches even more, but my goal was to say, hey, this is actually, like, if worst case scenario hits and there's no exemption from Congress, like, we can do this. We can do this, right? My softball pitcher, we had a great position description. We came up with a wage scale, and it might impact the softball pitcher's scholarship, right? Perhaps if that softball pitcher is on a 50% scholarship, which means, here at St. Joe's, she's getting in the ballpark of $37,000. Maybe it's not scholarship, and maybe we pay her wages directly to her student account if she chooses, or into her pocket. And, heck, we might end up saving money if we only pay minimum wage. I mean, I'm just speculating here and sort of trying to demystify the process to say, like, I never want my university to say we're getting out of Division I athletics if this happens. Instead, let's be problem solvers. But I think with the Johnson case in FLSA, the EEOC charges, the other thing, Greg and Christina, that people sort of gloss over is, we want Congress to say they're not employees. Well, there's 15 federal laws and a bunch of state laws. This isn't necessarily a one fell swoop where you can say under no state work comp law or under no federal Title VII, ADEA, ADA, the Rehab Act, ID, like whatever it might be that you can just, it's not that easy. So I'm preparing as if there are going to be changes and trying to sort of demystify it a little bit.
So because you kind of touched on this, but would it come down to a school by school basis? And this idea has kind of been proposed in there's a few different ways it seems like it could happen. It could be people talk about the revenue sharing model, people talk about the minimum wage model, or there could be contracts the same way that they have in professional sports. Is there one best way, or would it come down to the schools to kind of work out what's best for them?
Yeah, I think let's start with revenue share. And again, I think what's happening and what we're seeing is that there could be another state by state approach to revenue share. I think New York, had a draft bill, a pending bill that included rev share for institutions in the state of New York. I think that would be very, very difficult. But when we talk about revenue share, and I understand that this is a very, very complex issue, and I'm not trying to reduce it to this, but I teach class, and when I tell folks, why do we at St. Joe's have Division I athletics? What do you think they say immediately? What is the assumption of the general public?
And probably to make money.
Exactly. Most schools our size are subsidized by the university to the tune of 80%. Mm-hmm. That is across the board outside the Power Five. Mm-hmm. That means if my budget is, $20 million, the university is handing me 16 million of it, and I'm generating 4 million of it. Mm-hmm. And so what am I sharing? Well, what am I sharing in that scenario? Mm-hmm. You could start by saying, okay, if my budget's 20 million, 9 million of that goes to athletics aid. Do we want to take all that away? Because my favorite thing about college sports is people who otherwise would not have access to college getting to college. Mm-hmm. And so I think rev share, whether it's state by state or even federal, would have to take into consideration that every institution is so incredibly different. I happen to work at one in my life that's expected by the university. The athletic department is expected by the university to generate a surplus at the end of each year. That is extraordinarily unusual in Division I college sports. So I think that's those are some of the issues with rev share.
I think that's so crucial that you just explained that, Jill, because I can tell you, and Christina, in my experience, so many people have no idea. They just think that college sports is rolling in money. They see the TV contracts, they see the coaches' salaries, whatnot, and they just think the money is flowing, and they don't understand why these student athletes should not be compensated. And I really appreciate you sharing that, because so many people, and I'll call it ignorant bliss, but bottom line is just don't understand the reality of college sports. They think the money is just rolling in, and they don't understand, like at your school, if you have 19 varsity sports, I'm sure more than half, if not close to 3/4, are non-revenue generating sports. Am I correct?
To generate revenue. We sell tickets to 2 sports, right? Yeah. But then you think okay, so I educated my students. Why do we support it? Well, I've got 60 men on my men's lacrosse team and 40 women on my women's lacrosse team, and they each get 12 scholarships. So you do the enrollment math, right? Wow. They each get 12 full rides to spread over 60 and 40 student athletes respectively. So the reason many of us host Division I athletics is enrollment, and both direct and indirect, right? My men's rowing gets 3 full scholarships to spread over 40 guys. So that's 1.5 million in tuition to the university. Mm-hmm. And so, and there's so many other reasons. I mean, look at Fairleigh Dickinson, and look at FAU, and look at St. Peter's, the catching lightning in a bottle or having sustained excellence. I mean, college athletics literally transformed Notre Dame from a small farming town, small town farming school into what it is now. Newt Rockne put it on the map. Villanova has completely transformed. I think Nick Saban is the most underpaid person in the country, because he has single-handedly reformed what Alabama is. I mean, they've gone from in-state to charging massive amounts of money and having massive wait lists for out-of-state. And so, that's the power of college athletics. But when you look at rev share, what you get from media rights, there are 32 conferences in Division I, ranges from 20,000 per school to 55 million.
Mm-hmm.
And
Wow.
so rev share looks, very, very, very different. So that's, it's a complex onion to peel. I know people want to make it, and, let me give you one more complex onion. Is you got a lot of people, general public and others, saying you have to give lifetime medical to student athletes. Okay, so let's peel that back a little bit. And this is another where we talk about amateurism. They are not my employees, so I insure them on an accident plan, right? And accident plans have limits, right? We will pay for an injury. We'll pay for your medical care 2 years beyond the date you sustain the injury. If the injury becomes expensive enough that it hits 90,000, everybody in the NCAA kicks into the NCAA's catastrophic plan, which can pay up to $20 million lifetime. So it's not like we're sitting here saying we've got no plan for student athletes if they get injured. We have a catastrophic plan with a $20 million lifetime benefit. We have accident plans that cover our athletes for 2 years beyond, if it's related to an injury. But to say lifetime medical care for all student athletes, what do you think? Who's going to insure that, and at what cost? Because what's going to happen is causation, right? I have a guy who had a catastrophic knee injury at St. Joe's. Luckily, he recovered, and he's playing in Euroball. Right. And so then he's going to say, okay, lifetime insurance from St. Joe's, you got me. And I'm going to say intervening causes. You've been in Euroball for 17 years. And right. So, even something that sounds so student athlete friendly, like I'm not going to find an insurer to give me lifetime medical for our student athletes. It's just not how insurance works.
I think so you're driving home the point, which is crucial. And I don't interrupt you, but right now, I think we have so many legislators on the state and the federal level who are ill-informed. Yeah. Or who's so politically bent one way or another that they're not looking at the reality. And I'm hoping that people like Charlie Baker and yourself will continue to speak up and educate, will help them understand what you just described with insurance is really unbelievable. Because how could you possibly, number one, secure that insurance, and number two, be able to afford that insurance if you extend that out over the next 30 or 40 years with all of your student athletes? Unbelievable. Yeah. So I appreciate that explanation, because so many people, again, the whole goal of our program today was to help people understand things better from your perspective. And that's such a great answer to that problem, that dilemma that you're facing. One of the other things I wanted to ask you, okay, Christine, I'm sorry.
Oh, sorry, Greg. I mean, beyond even just which schools are making even enough money to support paying student athletes, right? Aren't many of the schools supporting their non-revenue generating sports with the money that they're bringing in, even at the Power 5 conferences? I mean, what happens then there?
Yeah, I mean, let's start with, to give you a sense of how the money flows. College football playoff money flows only through the college football playoff, right? The NCAA is not a part of that. So the NCAA brings in $1 billion a year. And again, you say, oh my gosh, they bring in $1 billion, they're getting rich. No. They're spending $400 million a year on overhead. That's running 90 championships across 3 divisions, very few of which make money. That's, having an enforcement division, having an educational division, running their overhead in Indianapolis. I mean, all of the stuff. So they put $400 million out, and then they redistribute $600 million to the institutions. Mm-hmm. But by the time those pieces of pie come, they get, pretty small. And this is what you've heard about with the gender equity report in basketball, is one of the many ways, the formula to redistribute that money to member institutions. There are multiple factors. One is sports sponsorships. So the more sports you sponsor, the more money you get. Another one is financial aid. The more aid you give out to athletes, the more money you get back from the NCAA. All good. But one of the major pieces of that pie that comes back to institutions is through the men's basketball unit. And the reason is, on the surface, I mean, the reason is clear, is because the $1 billion comes almost all from men's basketball. Mm-hmm. That's essentially historically been the CBS contract. And so historically, one of the prime ways you get money back is through a unit. And so that unit goes through your conference office, and then by conference bylaw, it determines how you share that unit. So if the ACC has 8 teams in men's basketball championship, and they count the number of games each of those 8 play, and then they get a major distribution from the NCAA based on those units. So if someone makes it to the Final Four, they played in the first round game, the round of 32, 16, 8, 4, they get 6 units times the amount of the unit that year. And then the ACC bylaws say how it distributes those units out, whether there's an equivalent share that everybody gets a little piece of the pie, or the schools that made it get more, et cetera, et cetera. So what you heard with the gender equity is, wait a minute, of course schools aren't investing in women's basketball. There's no unit. There's no payment from the NCAA, a redistribution, if you succeed. Mm-hmm. And so I'm getting way off top of your question, Christina, but the bottom line is, I think one of my things is the finances of college athletics are one of the most misunderstood and complex issues that are out there. So in most institutions, a huge amount of their, to put it very simply, a huge amount of their revenue comes from the revenue sports, right? Whether at that institution, it's football, men's basketball, women's basketball, hockey, baseball, softball starting to generate revenue, volleyball starting to generate revenue, depending on your ticketing policies and corporate sponsorship and so on and so forth. So, but there are some that don't generate revenue. And so most of the revenue comes in from football, and from, some of those other ancillary amounts come in from those other sports. And then to your point, Christina, yes, that becomes your budget to then spend it on all 26 or 22 or 20 sports that you sponsor. And so I think, you hear people saying, well, if we have to do this or that, we'll just cut a bunch of Olympic sports, as they're so called. I do think that concerns me a little bit, because we're the people who got into this market of paying coaches millions of dollars. And so the reason I wouldn't have money to keep fencing is because I'm paying my offensive coordinator $3.2 million a year, right? When a fencing budget's probably $250,000 a year. And so I think a little bit of that, I think people box themselves into a corner when they cry, we don't have any money, and we'd have to cut sports. So, the reality of it is that, at a school like St. Joe's, I would think I wouldn't have to revenue share, because I'm not getting any revenue. I'm not getting much revenue. And if anything, it would be de minimis. And the last thing I want to do is freak anyone out saying that I'm going to have to cut sports if we become employers, because like I said earlier, sports athletics does so much for St. Joe's, and it has nothing to do with revenue. So I think it totally depends on the institution. And I think it's really, really complex stuff in terms of, I will say, just taking one more step back before I turn it over to you guys, the United States is incredibly unique in that we even use college to train people for the Olympics, right? If you're a speed skater in the Netherlands, you don't go to college, you go to the Netherlands Training Academy. If you're a good athlete in China, you go to the Chinese Government Training Academy. And the number of Olympians, both US and other, who come out of colleges is really extraordinary. And so I do think somebody should have a plan. If college athletics is not going to be the home of Olympians, what's our plan B? That does concern me.
Mm-hmm. When the few minutes we have left, I just want to switch gears for 1 second. We've heard so much over the last several years, going back to Northwestern and the efforts to unionize the football players there, and the players actually signing authorization cards and having an election, which was then embargoed. And right now we have a regional director in California, as well as the general counsel of the labor board, pushing forward on a complaint, which will end up in a trial, which involves the student athletes at USC and their efforts to have USC and essentially the conference and the NCAA become joint employers. Everyone talked about unionization, and it was interesting to me, and I just want to get your thoughts, that not one student athlete during this whole period of time stepped forward from any school in the country, any school, despite the urging from Ms. Abruzzo to file an unfair labor practice charge in an effort to stimulate this. And I was just curious where you see that going, and whether or not on your campus and other campuses that you see any interest frankly, in unionization and collective bargaining among your student athletes?
I haven't. It did something that Jack Swarbrick, my boss at Notre Dame, who's a brilliant man. Back 10 years ago, we started a steering committee at Notre Dame that has a very, there's always been a SAC, Student Athlete Advisory Council. They're active in community service and all sorts of great things. But this was Jack's right hand. I mean, they weighed in on Under Armour versus Adidas versus Nike. They weighed in on, some really, really serious and important decisions for the university. And I've replicated that at St. Joe's. And so there's a group of 12 student athletes who have the finger on the pulse of everything that we're doing in this department. And really it's to say, you should be driving what's happening. We're here for you and your experience. And so I talk about these issues very openly with our athletes because I value their input and I want them to not just believe what they read and to really understand what's going on. And so I know I don't think there's a lot of interest. I do think also, it's talk about another area of mass panic. Okay, if one case goes in favor of somebody decides that student athletes are employees, like what has to happen for that to take over America? Right? First of all, what percentage, I know it's growing, but what percentage of 18 to 22-year-olds in the United States are unionized? It's very small. You've got to get students who are here for 4 years. Look what the troubles that grad student unions have because of the lack of continuity and leadership. I'm not saying it couldn't happen, but you've got, you'd have to have somebody step forward and say, we want to have an election. You'd have to have an election. You'd have to define the bargaining unit. Is it going to be all athletes? If so, you know who the president's going to be. It's going to be the fencer. It's not going to be the, and so, and if I have it, Jack always used to say, if we have a union, I want the fencer to be the head of it. And so I think, you've got to define your bargaining unit. You've got to go through an election. You've got to survive continuity of changes in leadership. Like I don't even think the declaration or the finding in one case means that we're going to have unions all over the country in college athletics. There's the public issue. I think in the Northwestern case, I think the NLRB, which was very different composition than it is now, maybe some would argue appropriately punted, not to use, and I guess that was pun intended, punted the issue saying, look, this is a public policy issue. We can't have the privates in a competitive field. We can't have the privates having unions and the public's not. And so, just looking at, you talk about the mess that is, if you have different rev share rules by state or different NIL rules by state, if you have only the privates, and I know the joint employer argument and all those sort of things, but, I think that there's so many steps before we get to every football or basketball player in the United States is unionized that, again, I look at this as how can I make sure my student athletes have a voice? And if it comes to the point where they want to form a union, we'll certainly talk through it, but I think there are a lot of, I'm trying to, again, demystify and make sure our coaches and athletes aren't in a panic about this. I don't think it overnight changes and every single sport crops up with a union.
Mm-hmm. I think you're right, and I agree with you 100%. I think the other issue, too, that I've heard from numerous people is the fact that just because they were and do have the ability potentially to unionize, they might not want to unionize because they have NIL rights. So the old theory goes back to, why do I want to be a member of a union and pay union dues and be subject to their rules and their constitution when I'm fortunate enough to be on a scholarship and also on top of my scholarship have a chance to make extra money? So I think I'm hoping that, there's a lot of fanfare, there's a lot of drama going on about the NLRB and where that's headed with an upcoming hearing in front of an administrative law judge. But I just wanted to get your opinion, because I thought that opinion I'm hearing more and more, which is, we don't have any interest in unionizing. We're happy the way we are. Our schools treated us wonderfully. So that's going to be one of those interesting ones to watch here. Everyone keeps talking about the Johnson case. And I know you touched on that. But that's also, I thought, an interesting case, which, we've had some similar cases that have gone all the way up to the circuit courts where the student athletes have remained student athletes based upon regulations that are in the formal FLSA policy manual. What do you see, if you can speculate just momentarily, on the distinction with a Johnson case as compared with an NLRB case? And I know you touched on Johnson briefly, but I was just curious to get your opinion on that.
Yeah, obviously tracking Johnson very closely and thinking, but again, I think it'll be some time. if I'm not mistaken, and I'm not the lawyer anymore, but if I'm not mistaken, it's the very early stages. And so if the Court of Appeals kicks it back, I think the world can change substantially in the time when the district court would, whether there's a trial or they grant summary judgment for either party or whatever, and that gets appealed. And I think that there's some opportunity for us to start looking at, okay, let's look at, we might not be able to totally control or at all control Johnson right now, other than begging Congress for an exemption. But what are some things we can control? And this is both unions and Johnson. I look back and I say, how are we treating our student athletes? And one of the things, I already told you about the complications of medical care, but I think we do an outstanding job, right? Nobody has out of pockets for any injury they sustain in athletics and for 2 years thereafter. And then we just don't see many claims after 2 years. Like, that seems to meet everybody's needs. And if they are still suffering after 2 years, they're probably in the $90,000 claim catastrophic plan. But, what I'd like to do, and if I had spare time, I would be out there, because we're one of the best risk management and insurance schools in the country. I'd be out trying to figure out how we can get a mental health rider. Because right now, our student athletes, when you take kind of I don't know if you guys are aware, for example, with sports betting, and this is something college athletics has been saying from day one, that how many death threats student athletes get if they miss a free throw at the end of a 17-point game because they didn't cover the spread. There have been numerous colleges and universities having to call the FBI because of what's on the social media, the DMs of their athletes. And I know Baylor went public. There's a great article for those of you, just look at Baylor, FBI, and sports betting. Can find out what that young man went through. But, mental health's a thing. It's a thing for so many reasons. And, right now we're kind of saying, hey, there's campus counseling, and more schools are hiring sports psychologists for their department. We have one. He's a contractor. He has a postdoc working with him. But you're never going to meet the needs. And there's going to be some people who just want to go out in the community and get specialized care, whether it's an eating disorder or whether they simply don't feel comfortable going to campus to get mental health. And so, let's get a rider for these accident plans that covers mental health. And, those kind of things. I'm like, let's do whatever we can to treat the symptoms before we go rushing too far down, oh my gosh, what if unions are here and what if FLSA is here? And I think there are a lot of intervening steps before we get there on the Johnson case. That being said, I am trying to demystify it, have brainstorming and whiteboard sessions to say, what could that look like at St. I don't care what anyone else thinks. What could that look like at St. Joe's so I could maintain 487 athletes in 20 sports?
Mm-hmm. And that'll likely be a patchwork the same way as you just described with the NLRB, right? Where, even just before Alston, the the 7th and 9th Circuit courts, they went the other way on it. This is kind of Johnson's looking like it's going to flip. By the time the other jurisdictions catch up, very well likely will be that each jurisdiction is just kind of functioning in this piecemeal way, right?
Yeah. And, you referenced I think it's Berger and Dawson cases that have said student athletes are not employees, so if there's a circuit split, will the Supreme Court take this up? I think there's a legal journey here. And I understand that the NCAA is hoping they can work with Congress to get maybe an FLSA exemption before then. Yeah. But even if not, should we be sitting down with the Department of Labor and saying, having conversations about what the rules and regs look like? And, do we need Congress, or can we get the DOL to come out with something? Who knows? And I'm sure it depends on who wins the White House, which I think will happen before the Johnson is done winding its way through. So taking a more measured approach, I'm trying to really get my finger on the pulse of how our athletes are spending their time. I'm doing more surveying to make sure they can pick the major of their choice, because FLSA comes down to control. Mm-hmm. What I heard in both the oral argument and in the opinion was that the court is saying you control these athletes and their daily schedules. Well, one of the proactive things I did because of my legal background when I got here is do a student athlete survey every year. And I asked them, did you have the opportunity to pick the major of your choice? And I've not had one student athlete yet say no. Mm-hmm. And so to me, that's what I would show, and say, look, I've got nurses. I've got, we have a 4+1 nursing program, but I have pre-nurses. We've got, finance majors. We have food marketing co-op, which means they have to work hours for a retail establishment. We've got those students. And so we're not the kind of control here at St. Joe's that you're talking about, Third Circuit. We're far from that. So, but I want to keep the finger on the pulse of, we have mental health days for our coaches, right? They give the student athletes like 3 days to say, I'm not coming to practice. I don't know if you guys have them, but my late mother, who just passed, was a therapist, and we got 3 mental health days per semester. She didn't want to teach us to lie. She didn't want us to pray for snow. She wanted us to be able to wake up and say, Mom, I'm not going to school today. No questions asked. And I have suggested that to many of our coaches, and most of them are doing it, and our student athletes love it.
That's great.
At the end of the day, you and your potential as people are the most important thing here. So what can I keep doing to create a culture where they feel loved and cared for? We have a star basketball player who just came out and said, I'm not transferring. Of course, everyone's like, you guys don't even have an NIL collective. Surely he's transferring. And it was really gratifying. He said, I'm staying because I love the coaches and they love me. And when I got here, I said, we're not going to pay him to death. We're going to love him to death. And that's the culture. Certainly, I hope people can tell I'm not sitting here watching the Titanic sinking, thinking we're going to love our way through this, but we are going to continue to love our student athletes and let them know this is about more than money if you choose to come here. This is about having a family and having a support system and teaching how to be adults.
And I think that's a philosophy that's going to be adopted and has been adopted more and more, that we're seeing more frequently, because not everyone can be a Power 5 school, as you said. And a lot of people don't want that Power 5 experience, perhaps, because, again, everyone's not going to be a professional athlete. They want to go to college, combining their love of athleticism with their education.
Absolutely.
We're just winding down here. I just have one last question I wanted to run by you, and I know Christina wanted to cover it as well. As we see Charlie Baker and I'll call it a new administration at the NCAA emerging, what do you see as his biggest challenges, and what do you see as his ultimate goals and what he wants to accomplish? You highlighted those other 3 issues at the beginning of our conversation, but I was just curious what your interaction has been with him, if any, and what you're hearing about where he's headed and what he wants to accomplish.
Yeah, as Christina mentioned at the beginning, I'm back on the women's basketball committee, which means I've been since March 6th, when we gathered in Indianapolis to select the tournament bracket. I went straight to Bloomington, Indiana to cover the first and second rounds, straight to Greenville to cover the regional, and straight to Dallas to cover the Final Four. So I've been on the road for a month, and I've gotten several opportunities to meet with Charlie and hear him speak. And I think one of the things he says, and I think he's right on, is, there's a lot of external work that needs to be done with Congress, with media, with others. But there's a lot of internal. People within NCAA member institutions don't agree on the path forward. And that's in large part because, membership associations are supposed to be associations of like-minded members. And in some ways, we're not as like-minded as we used to be. And so I think he's got to help convince the membership that there's a way forward that everybody's going to have to give. Right. I mean, as a small institution, we've had to give competitive equity, because every time you pass a rule to protect competitive equity, it's challenged under antitrust. And so that's where I've kind of said, forget benchmarking. We're going to do it our way. So I think he's really has to ensure that the membership, the 350 plus institutions that make up the D1 membership, are willing to give and understand that there's no perfect solution here.
That's such a great answer, because so many people view it as the exact opposite, that it's all external. And that's just a great point. I'll let Christina wrap up here, but on my own behalf, I want to thank you, Jill, for so much for your time and really providing our listeners and our audience with such great information that, frankly, that was exactly what we were trying to do and hoping we'd be able to accomplish. So I'll turn it over to Christina to wrap it up here in the last minute or so.
Well, so I was just going to say, we have one question from our audience.
Oh, okay.
I think you kind of touched on this earlier, Jill, but I'll let you say it anyway. So the question is, I understand your cautiousness for student athletes, but do you see the recent changes allowing student athletes to earn money as a positive or negative change?
Yeah, total positive. And we've got to get some, I've been on every NIL committee, and we had these big ideas of a third-party administrator where you registered and there was some sort of fair market value. Like, that didn't happen. And so I think there's some guardrails that could come out to protect both the student athletes and the recruiting inducement and pay for play. But generally speaking, I love it. I love, I had the opportunity to be with the Cavender twins with Miami women's basketball, and seeing them be in the Elite Eight and making millions of dollars is pretty cool.
Definitely.
Well, on behalf of Louis Brisbois on our collegiate professional sports practice, and Christine and myself, we can say nothing but thanks and appreciation for you spending your time with us and providing such great insight and information to all of us and all of our audience listeners. So thank you, and we wish St. Joe's luck, and hopefully we'll see you in the Final Four next year.
I love it. Thanks for having me, guys. Really appreciate the conversation.